Hello, my name is Uzair Kayani. I'm on the Faculty of Law at the Lahore University of Management Sciences in Pakistan. Professor Sikandar Shah and I have been working on curriculum development of business and human rights. He's also on the faculty here, a senior faculty member, and we've been supported in this work and guided very graciously by the American Bar Association Rule of Law Initiative. So the idea behind this project is to build both an academic and a grassroots interest and awareness of business and human rights. And business and human rights, of course, is a key area of both of our research interests. My research interest is largely in law and economics and business law. So that is the business side, as well as international law issues that affect businesses and also private individuals. Professor Shah focuses on international law issues, and particularly these human rights treaties that create the hard law background of business and human rights. So we've been working with the American Bar Association for about 2 years on this, and we were able to develop a pilot course a couple of semesters ago and offer it to a select group of our students on business and human rights. The main parts of that course, to introduce it, before I talk about its future directions, were as follows. So we began with the hard law approach of looking at the applicability of core human rights treaties such as the ICCPR, ICESCR, and CRC, and CEDAW in Pakistan, both when those have been domestically implemented, because Pakistan is a dualist state, and also at some cases where they were used as persuasive authority, even though they weren't binding by court decisions. So we began with court decisions of the Pakistani Supreme Court and the high courts that tried to apply, either as persuasive authority or in the case of implemented law binding authority, human rights treaties against in some cases, private entities. Now, this happened typically in an indirect way, which is one of the interesting things about Pakistan, is that you have to, the case that the plaintiff makes is that the reason the private entity is acting in this way and violating human rights is because some public entity is actually not doing its job regulating it. So, for example, this business is polluting because the Environmental Protection Agency is not doing its job to stop this business. And so that indirect route allows for, in many cases, the writ jurisdiction of Article 199 and Article 184 to be applied to a private party just because there happens to be some kind of a link or a hook to a public party. So we began with that. Then we moved on to the soft law approach, which is basically the heart of this, or at least the beginning point. I shouldn't say the heart anymore, but the beginning point of the UN Guiding Principles in Business and Human Rights. So John Ruggie, he was a UN Special Rapporteur on Business and Human Rights, wrote a book detailing his experiences called Just Business, about why it was so difficult to have binding instruments control these multinational corporations, and then how he came to this soft law approach, which has become much more influential and pretty much standard now across many businesses, as well as many countries that are developing their own internal policies and national action plans. So the UN Guiding Principles, we look at the 3 pillars of the UN Guiding Principles. First, the state's responsibility to protect. Second, the business's responsibility to respect rights. And those are not necessarily coextensive, because in many cases a business will be based in country A, which has some human rights protections, and be operating in countries B, C, and D, which don't have those protections. But the business would still have a responsibility to respect country A's protections wherever it's doing business. And their investors make sure of that. In many cases, the state's own laws make sure of that. Domestic laws, such as in the US, the Alien Torts Statute and so forth, and in the European Union, the ability of people to sue parent companies that are based in the European Union or in the UK, that is allowed for countries to extend their protections extraterritorially as well, at least insofar as businesses that are based in or operating in their countries are concerned. So we take a look at that. UNGP side. And on the remedy side, the most interesting stuff that we are able to cover, the two things that I would mention are, first of all, internal business remedies, where you actually don't have to go to court, but can, in some cases, for some businesses, you may be better off going directly to the business and applying to their remedy procedures, especially where human rights are weakly enforced. And then contrasting that with the litigation approach. And then the second point, arbitration and alternative dispute resolution, which has proved very useful here. Next, we move on to the OECD and its national contact person regime, where you can actually, if there's a business that is operating in your country, such as Pakistan, and they're based in, let's say, Germany or the UK or the US, then you can apply to a right to a national contact person and tell them how that business is violating human rights. And many labor-based businesses have used that route in Pakistan. So we consider some of those case studies as well. And then we move on to this idea of arbitration. We're judging what the best approach is in some case studies that we create. Should it be arbitration? Should it be suing in domestic Pakistani court? Should it be suing the parent company if it's available in the courts of that foreign jurisdiction? Or should it be the internal business and grievance procedures of the business? So that's basically what we've been doing. And our plan is to offer this course again in the spring. Now, the first course we offered was a pilot course, very research-based with the final project. And that was, in fact, about 12 to 15 students. We will probably be looking for the same size for the immediate next course, because I'm going to be updating that with some materials which we haven't tested yet and we're curious about, like this European Union regime of mandatory human rights due diligence and so on and so forth. And then we hope to regularize it as an elective. So a freestanding elective course at LUMS, at the law school, which will be offered once a year, or maybe in staggered terms. We haven't actually decided that. The second thing that we're considering doing, which we haven't taken this approach yet, is to involve or incorporate more BHR material in some of our core courses, just as very small modules, like 1 or 2 classes. For example, in corporate law, you could actually have, or business organizations, you could have this BHR section, as well as international law, as well as torts, which I teach. So that's a second possibility that we're exploring. So I'd like to encourage students to explore the elective course. I think it went, from the input and feedback we got, it went well the first time we did it, and we'll continue to improve. Pakistan is making its own national action plan right now on business and human rights. So it is an area that is active, and we want it to remain active. So we'll play our part by refining our course and continuing to offer it, as well as supporting other schools. So thank you for your time, and stay safe. So I guess we'll